The court. The state may call its next witness. Attorney Fallon. Yes, I'm going to call Lieutenant Bowe. The clerk. Please raise your right hand. Lieutenant Brett Bowe, called as a witness herein, having been first duly sworn, was examined and testified as follows. The clerk. Please be seated. Please state your name. Spell your last name for the record. The witness. Brett Bowe, B-O-W-E. Direct examination by Attorney Fallon. What do you do for a living? I work for the Calumet Sheriff's Department as a deputy. The court. Mr. Bowe, can you move the microphone over, please? Question by Attorney Fallon. Say that answer again. I work for the Calumet Sheriff's Department as a deputy. All right. What rank do you currently hold? Patrol Lieutenant. All right. How long have you been so employed with Calumet County? 16 years I've been there. And how long have you held the rank of lieutenant? Almost 2 years. What were your previous duties? Prior to that, I was a patrol sergeant. Before that, I was a patrolman. And I was a jailer for a year and a half. All right. Directing your attention now to the week of from November 5th to November 12th, were you involved at all in the execution of a search warrant on the property of the Avery Auto Salvage Yard and the residences located therein? Yes, I was. And in what role or capacity did you have with respect to that? I was in charge of the command post. All right, and specifically, what duty were you assigned? My main duty was to guarantee security on the property and also to coordinate the searches. All right, and in terms of the security, who else did you share those responsibilities with? Lieutenant Sipple. All right, and in terms of yourself and Lieutenant Sipple, how did you work? In other words, were you both there at the same time, alternating shifts? What'd you do? During the day, we were there at the same time. He started on Saturday morning. I arrived Sunday morning. He left Sunday night. I would have stayed through the night. He would have come back Monday morning, and then I would have left Monday night. And we kept alternating that way. All right. So we were both there during the day. All right. We have heard some testimony already from Lieutenant Sipple, so I don't want to repeat that, but I have a question for you. Are you familiar yourself with any attempted breaches of the security that you were involved in ferreting out? Yes, I am. Tell us about that. There were 3 that I was aware of. There was one that I personally involved with. All right. Is that the one you want? If need be, there should be a laser pointer in front of you, and there's an exhibit to your immediate right and one behind you. In terms of the incident you were involved in, tell us about that. The incident I was involved in, the officer that was stationed down in the southeast corner notified us that he had observed a person on the berm to the south, which would have been located a little further south than what this map shows. All right, and you just briefly turned and pointed to Exhibit 19, and the one on the chalkboard? Yes. All right, and if that assists you better, tell us about what occurred. The officer indicated that there was an individual just south on top of the berm. I proceeded around to the quarry and got up on top of the berm, and I could see a set of footprints that came along there. There were approximately 20 yards south of the southeast corner of the property, and I saw that the footprints led to a residence that was just to the east of where the footprints were. So I followed them up to that residence. All right, and were you able to ascertain who was responsible for the footprints and or the attempted entrance? I spoke with the gentleman there who indicated that his wife had just left for work. He indicated that she had gone out and had fed their dog and was gone for approximately 5 minutes, and that he had heard her car leave at that time, and that was the only person on the property that could have been back where we were. All right, in terms of your particular time while you were in charge, were there any other perimeter attempted entrances to the inner perimeter as it's been described? Yes, there were. There was an individual that was also in the southeast corner, further north, so they would have been just east of the property. And Lieutenant Sipple addressed that. That was a member of the media. And then there were two gentlemen that came in from the north on the west side of the property, were walking a line fenced down, and I believe they made it about 2/3 of the way down through the 40-acre field. And when they saw numerous officers approaching them, they turned and headed back toward the north, and they were apprehended. All right, north of that property. All right, and during your time when you were solely in charge of the perimeter, were there postings at each corner of the perimeter? In other words, was there the euphemism of today, 24/7 security? Yes, there was. All right. Attorney Fallon. That's all. The court. Mr. Buting, any questions? Attorney Buting. None. The court. Witness is excused. Attorney Fallon. I believe Exhibits 18 and 19 have already been received, so that being the case, just in the odd chance they aren't, I would move for their introduction. And secondly, we would rest the presentation of our evidence on this issue. The court. All right. With respect to 18 and 19, have they been admitted? The clerk. Yes. The court. All right. They are already admitted. Any rebuttal witnesses from the defense? Attorney Buting. None. Are there any exhibits that are not admitted? I should. The clerk. Everything is received. Attorney Buting. Everything is received. Okay. Thank you. The court. All right. Does that conclude the witnesses then for all the outstanding motions at this time? Attorney Strang. The only thing I will add is I should have thought to do this yesterday when I had Mr. Glenn on the stand, but I will make an offer of proof on what his answer would have been had the hearsay objection not been sustained. I expect Mr. Glenn would have testified that, as he had said something to the effect that he had told Mr. Avery that he wanted Mr. Avery to tell the officer that he didn't wish to speak to the officer without a lawyer. And Mr. Avery agreed to say that, with the cell phone the line still open, and Mr. Glenn heard that. He thinks before Mr. Avery got into the car, heard Mr. Avery saying to somebody, nearby, I don't want to talk to you anymore without a lawyer, or words to that effect. The court. All right, is that Attorney Fallon? Obviously, we still hold to our objection. The court. Let me ask this. Is that something that was on the CD transcript? Mr. Strang. It's not on the transcript, but, the tape goes off and then comes back on as Avery, I think, is probably getting into the car. The court. Okay, so that's a statement, had it been admitted, that the defense would have contended came in between parts 3 and 4 of the tape recorded. Mr. Strang. That's my best inference. That's an inference only. Attorney Fallon. Then I have a second objection to that, and the second objection is that's speculation on the part of Mr. Glenn as to when that occurred relative to the getting into the vehicle or the turning on the tape, because he wasn't there. So now I have another grounds to object. The court. Okay, I didn't understand that Mr. Glenn would have said that. I understood. Mr. Strang. Glenn thought it was before Avery. If you assume Avery was out of the car, Avery says it right away, before he would have had a chance to go and open a car door. Glenn doesn't hear car doors opening, and there's no pause in there. The court. All right, I would like to take a short break at this time to meet with counsel and determine what else we're going to do today. Attorney Kratz. Judge, could we just have a moment? The court. Yes. Attorney Fallon. Judge, before we do that, I would like you to make a record on 2 points, since it appears that the testimonial part of this motion is now ended. With respect to the Franks motion, and most importantly, with respect to the state's challenge to his standing to even raise a challenge, that you engage in a colloquy with the defendant, Mr. Avery, that he did, in fact, have a right to take the stand and assert his reasonable expectation of privacy in any of the locations subject to the search. Secondly, we would ask the court to engage in a second colloquy with the defendant relative to the circumstances surrounding the taking of this statement by the Marinette detective Anthony O'Neill. If he had the right to testify, he had the right to say in his mind what occurred and when things occurred vis-a-vis that statement, and he apparently has chosen not to. So I would ask that you engage in a colloquy with Mr. Avery on both of those matters before we close and move to argument. The court. Attorney Strang, the court. Just a second. Before I give you a chance to speak, Mr. Strang, your first request, Mr. Fallon, was to what? The right to privacy to Attorney Fallon. His right to testify relative to his right to challenge the search warrant. He had objected, demanded that he establish standing to challenge the warrant, and thus standing to bring the Franks motion. So obviously, he has that right and he has chosen not to exercise it. So that would be the first colloquy, that was a decision that he made with, presumably, advice of counsel, that he's given up his right to testify and offer his point of view. That's the first one. And the second one is his right to testify regarding the motion to suppress the statement to Detective O'Neill. The court. All right, Mr. Strang? Attorney Strang. I understand and appreciate that the flow of Wisconsin law in the last 15 or 20 years has advanced steadily toward inserting the court even more frequently into strategic decisions and decisions on which witnesses to call or whether to call the defendant in a pretrial matter, so I understand full well why the state makes the request that it does. I also acknowledge that I have invited the court on at least one or two occasions so far to engage in a colloquy with Mr. Avery, where we were requesting some relief or some indulgence, and I thought that would be the better way to make a record or to make clear that this was done with the accused's personal consent. That said, I'm not aware of any authority here that would invite the court to insert itself at this point in the decision on what witnesses to call on pretrial matters or on foundational matters in the case of the standing question or personal interest in privacy on a pretrial motion. And I think that, obviously, Mr. Avery has been present here. The record has reflected that all along. He's been awake. He's been an active participant at the defense table. But I don't think it's a wise move to have the court or then the adversarial party involved in every decision in the defense camp about what witnesses to call or how, strategically, to handle the pretrial motion. So, while the court will do as it sees fit, I don't think a colloquy on either of these points is either required or appropriate under the circumstances. The court. Mr. Fallon, I'm not sure. I understand what you're saying about the motion to suppress the statement to Officer O'Neill. I'm not sure with respect to the Franks motion. Attorney Fallon. The Franks motion is ancillary. The real issue is, does he have the right to even bring a Franks motion? Does he have standing to challenge the search? And he has to establish standing by a preponderance of the evidence. That's his burden. And if it's the defense burden, then one rightly ought to assume that he has the right to testify to assert his constitutional interests. And if he's choosing not to, that's fine. I just want to make sure that it's his choice, presumably with the advice of counsel. If not, we would be more than happy to accept a waiver of any subsequent claim in the future of ineffective assistance of counsel for not putting their client on the stand for purposes of completing the record on these two motions. The court. All right. I want to make sure that I'm understanding your point on the Franks motion correctly. I understand, and I believe the state has already asserted that the motion that was filed by the defense did not constitute a substantial preliminary showing that a false statement had knowingly and intentionally been made, or a statement with reckless disregard for the truth. You have made that motion, have you not? Attorney Fallon. Yes, relative to the Franks aspect of this. The court. Right. And argue that the court should not have even conducted an evidentiary hearing because the defense motion does not meet the initial plateau to be entitled to a hearing. Attorney Fallon. That's the second argument. The first argument, they didn't have standing to bring a Franks motion, except as it pertains to the trailer and the garage. His residence, the trailer, and the garage. The court, okay? Attorney Buting. Judge, it's the same warrant. Mr. Fallon has been making this argument for 2 days now. And the warrant, it's the same warrant. It involves his trailer as well as all the property. So how can he say he doesn't have standing to challenge a warrant that has his trailer residence on it? The court. Well, I suppose the state could argue that the court should find in the state's favor, and in the alternative, if the court doesn't find in the state's favor, it should only sustain the argument made by the defense as it relates to the trailer and the garage. I mean, I don't know if that's where we're heading or not. One of the things I was going to discuss with counsel in chambers was what we were going to do from here forward. And one of those was going to be to hear your arguments, because I believe I told Mr. Fallon I would hear his argument, which I have not heard yet. Attorney Fallon. That's right. So our only question is it seems to me that wisdom would suggest that we take colloquy from the defendant so that we're sure that he had the right to testify on these matters if he wanted to, and he's chosen not to. The court. Let me ask the defense, and I don't know that this is self-evident in the pleadings. Is the defendant asserting that he has a right to privacy that extends beyond the trailer, the garage, and the immediate surrounding area, if you will, that is, to the rest of the 40-acre parcel? I don't know that the defense has asserted to this point that the defendant has such an interest. Attorney Buting. Judge, I think it's pretty clear from the testimony that what we focused on, and from the motion, is the entries to his residence and to his garage and, the reasonable curtilage or whatever in that area. The testimony regarding the other aspects of the property is that he was basically an employee or worked there, not an actual owner of it. But that testimony went to the question of whether or not there was probable cause for the officers to have been in the location they were at before consent was given to the officers, such that the information that Detective Remaker obtained, that is, the VIN number, was improperly obtained and should not have been considered in the warrant as part of probable cause. In other words, if the Franks motion is granted and the court strikes that portion of it that is considered deliberately false or recklessly untruthful, and then you look at the remainder of the warrant to see if there is still probable cause, and that consideration has to, in my estimation, we can argue all this, but that's what the testimony went to, as to why that portion of the police observations could also not be considered in determining whether there's a probable cause. The court. All right, maybe I missed it. I know there was testimony that Detective Remaker didn't ask consent. I don't think he asserted that he asked consent before responding to the scene on Saturday and responding to the location of the RAV4 and looking at the VIN number. But I guess to this point, I also didn't understand that the defendant to be asserting that he had a right to privacy with respect to that portion of the property that would have required Detective Remaker to ask for the defendant's consent to visit it. I don't know. I mean, it's not clear to me in the motion papers that were filed what the arguments were going to be. That's why one of the reasons I'm going to permit each side to make oral argument, perhaps some of those points can be clarified. Is the defendant arguing that he had an individual right to privacy that was violated, that required Remaker to get consent or a warrant before responding to the location of the RAV4 and looking at the VIN number? Attorney Fallon. Excuse me, Your Honor. I think we're getting a little off track. Because we are going to argue these points shortly, the only issue on the table right now, as I understand it, is whether or not we're going to take a colloquy from Mr. Avery, that he was mindful that he had the opportunity to testify and chose not to. And if we're not, then that's fine, and then we can proceed to argument. I mean, that's the only... I don't want to mix up the two concepts. The court. Well, this is a pretrial motion. Let me ask you this, Mr. Strang and Mr. Buting. Have the two of you discussed this with your client and made a decision, after your discussions with him, that you would not be calling him to testify? Attorney Strang. We have not had extensive discussion about it, and I think beyond that, it's privilege. And really, there is the point. I mean, if we could do a colloquy with Mr. Avery, and essentially what the state would be hoping to accomplish is his ratification of decisions that haven't been his, strategic decisions about how to proceed on a pretrial motion and which witnesses to call and not to call, him included. If these calls are so far wrong that they fall below a reasonable level of defense counsel's performance, then that's the fact. And having him ratify them doesn't change that. The decisions on what witnesses to call here and which not to call, including Mr. Avery, have been mine and Mr. Buting's. The court. Well, I understand that. I guess my question is directed to something that falls a little short of actually conducting a personal colloquy with Mr. Avery, and that is whether or not the two of you have discussed this with him. I'm not looking to get into any privilege. Attorney Strang. No, and in a very general way, we have had very brief discussions about it as to these two motions. The court. All right. Attorney Strang. And I will say, discussion to the extent that implies a two-way discourse may be gilding the lily to some extent. I know that, very briefly, I've expressed an opinion or made an assertion. I'm not sure that beyond that I should be implying a two-way discourse. The court. All right. I'm going to take a short break at this time. Before I ask counsel to meet me in chambers, I'm going to ask that defense counsel addresses this issue with Mr. Avery, and we'll discuss in chambers how to proceed further when we come back out on the record after that's been completed. Attorney Strang. Is there a place where we can talk in private? The court. Yes, I believe the jury room would work for that purpose. Attorney Kratz. 2:15-ish? The court. Let's say 2:20. In my chambers. Attorney Strang. We can use the jury room, but that will require one of two things. First, preferably, all the law enforcement people or representatives of the state being outside a closed door. Or second, much less preferably, anyone who's within the room being deputized as a defense investigator for purposes of that meeting, and being instructed that he or she is within the lawyer-client privilege on the work product doctrine forevermore for purposes of what he or she would overhear. The court. Well, I'll meet with who's ever in charge of security and then address that with you after I do that. Recess taken. End of partial transcript.